My young friends, the most important ingredients of the writ petition are index, dates and events, that is synopsis, interim application, petition, enclosures, affidavit, wakalatnama. Everyone knows. I'm here to uh, explain the importance of one of the most important aspect of the entire ingredients of a writ petition is the petition itself, the affidavit. Let us come first to the petition because all these index, dates and events and stay application, they follow the petition. Petition, as I've already said, that it has three parts. Important one, that is the introduction, main body of the story, and the concluding part. Then the prayer. Now, why petition is important? Because petition gives you an opportunity to present the complete case of your client in a proper manner. Petition is really important because drafting a petition is helpful to you here at High Court, at Supreme Court also. So pleadings should be nicely and presented in the petition here. Now petition, before drafting the petition, foremost important thing is that the papers which you have received from your clients should be lined up, should be put in series, sequence wise, starting from the earliest date to the latest. Once it is done, then drafting a petition becomes quite easy. Such as, if it is a service petition, for example, then the date of appointment of the petition is required. Date of confirmation is required. Promotion, pay scale, unblemished service record has to be mentioned, any appreciation letter. After giving all these things, then this prepares a background of the client. After this, one can start dictating the reasons or the grievances, how they developed, how the difficulties occurred in his service career. Then ultimately, what orders were passed by the authority implicating him or which is causing loss and damage to him. Giving details of that order also. That order becomes impugned order. After this, now you have to describe how that order is bad in law. Then from here, the grounds begin in the petition. So now, facts presentation, then the actual grievance, then the grievance is based upon the grounds, which means which is in violation of certain law, or the impugned order is bad because it did not consider certain facts, it did not consider the representation of the petitioner, or it did not consider the past good service history of the petitioner in this way. So after setting the grounds properly, there comes the prayer part, relief part. Relief has to be molded appropriately. Relief part should not be very brief. It should give a description of the impugned order, on which enclosure number it is annexed, what order has been passed, in fact how it affects So one or two sentences must be devoted in the relief part, in the prayers, describing the impugned order also. Because once the court starts from the relief, then the relief makes the things clear in his mind, and also the purpose clear in his mind, for what relief the petitioner has approached the court. This is important because grounds, entire petition base is on the grounds. Now let us go another step. Once this factual presentation, the relief, the grounds are ready, then comes the role of dates and events. Dates and events are correlated with the facts presentation. Dates and events indicate that earlier what happened. For example, that first date and event will take place that he was appointed on such a date, and thereafter the promotion and also and so. Then some dates, how he received appreciation letter, then the date he received some letter which is implicating him or causing some charges, then show cause notice and other things. All the dates and events are put in a proper sequence to give an idea to the petitioner counsel as well as the court that how the petition is based. It is a sort of synopsis, it is a brief presentation of the facts as well. Dates and events does not include grounds. Now another point, once dates and events are clear, now the index. Index is the indexing of the enclosures and annexer. So all the documents which are in support of the facts which have been averred in the petition should be properly lined up, should be properly annexed, and annexer number 1, 2, 3, 4 should be given, mentioned in the index, starting from the appointment letter, then promotion, then pay scale, upgradation and appreciation. All these things are there. Then the impugned order also, then the show cause, before that is show cause notice and whatever is that. So in such a conditions, an index helps the petitioner counsel at the time of argument, when court asks where you have annexed, where is the order impugned, where is the show cause notice, where is the suspension letter, where is the termination letter, etc. Just by looking at the index, the advocate can give the page number, give the date also. So the index contains date, page number as well as the material. So index should not be very brief. Index should contain at least a brief description of the document which is annexed therein. I am emphasizing on this point because I have noticed recently that now index is taken least care, such as merely the date, order date, the date of order, without describing. How can we say that what order the index is indicating? Date of suspension order, date of revocation order, date of this. These 1, 2, 3, 4 important words if are added in the index, then that helps the petitioner counsel at the time of argument to correlate his argument, to present the relevant documents on being asked for without getting disturbed or without wasting the time. So index should be always in a proper manner and should be giving a description of the document which is annexed therein. Similarly, annexer, after the petition ends, the annexer should start, and annexer folio should also give a mention, at least a 1 or 2 line giving description of the documents enclosed therein. What I have noticed here, annexer contains annexer folio was parties number, etc., but no description of the document which are annexed with that annexer number 1 or 2, etc. So annexer folio should also give description of the documents. Now comes affidavit. Affidavit part is important. Affidavit part has who is swearing in, his detail, his name, his father's name, his occupation, his phone number, his Aadhaar card number, etc., his total address, his post, then how he is swearing in, whether he is representing a department, then one has to write that so and so has been duly authorized by the respondent number 1 so to file the affidavit. If he is representing himself, then one has to write in that affidavit the deponent is sole respondent or sole petitioner, and he is and as such he is well acquainted with the facts. If there are more than one petitioner and one deponent has been authorized, then there is no need of writing authorization. Merely the deponent is the petitioner number 3 and he is filing the present affidavit on behalf of the petitioner number 1, 2 and 4 also. This will do. Here authorization is not required. Here parokari is required. The deponent has to disclose his relation also with the other petitioners in the affidavit itself in order to improve the authenticity of his affidavit. Deponent is just next friend. It may be accepted, but in fact deponent has to give a brief description of his relation as to how he has been informed about the facts of the case, how he has come to the knowledge of about various facts, various orders. So deponent is just not a formality, but deponent has to establish his credibility. Under what circumstances he came to know about the documents, he received entire information which are being annexed with the petition here. And deponent has also to swear that he has read and understood whatever the contents of the petition and prayer is, including the affidavit. So deponent has to give affidavit swearing the paragraphs of the petition as on the basis of the knowledge, on the basis of the information, on the basis of the records, on the basis of the legal advice. On the basis of the knowledge, when the information given in the paragraph or the averment given in the paragraph is solely based upon his knowledge. For example, deponent is the parokar and doing parody on behalf of 1, 2, 3, 4, etc. This is on the basis of the knowledge. In writ petition, deponent is writing that he has not received any caveat. This is also on the basis of the knowledge. Now, definitely the paragraphs in the knowledge are very limited ones. Now, information, sometimes it is baffling and confusing when to fill up a paragraph numbers in the information column. Information column when actually the deponent has received some information from either the relative of the petitioner, friend of the petitioner, villagers, other office bearers, office colleagues, okay, information from some news articles, and he doesn't have copy of that news article to bring on record. So in that condition, the information column has to be filled up in relation with the paragraph of the writ petition. Now the record, so far as record is concerned, most of the factual aspects which have been narrated in the writ petition are based upon certain documents. Those all come in the records. One has to be very cautious. Sometimes in the paragraph itself, the averments partly are given related with the records, partly are given with related with the or based upon the knowledge. Then in that condition, merely writing records in the affidavit column would not suffice. That would require part knowledge, part records. That means paragraph number 7 with P capital within inverted commas after the paragraph number 7 in the records column as well as in the knowledge column, which will indicate that this particular paragraph 7 has been shown both on the basis of the knowledge as well as on the basis of the records. Now legal advice. Mostly last paragraph, that is in view of the aforesaid averments and facts and circumstances this honorable court may be pleased to. This is normally written in the legal advice column. But in fact, legal advice column is very important and it expects an advocate to fill up, to refer those paragraphs also which gives reference of some judgments, reference of applicability of some law, applicability of some judgment passed by the coordinate bench. All these are based upon the legal advice. So therefore, the legal advice column should be a bit exhaustive, not just confined to the last paragraph. of the petition here. Or the other column in which one writes that there is no other alternative but to approach this on a court under Article 226 of the Constitution of India or 227 of the Constitution of India. This is also written in the legal advice, because here the advocate or here the deponent is swearing that paragraph on the basis of the advice of the advocate that there is no other alternative. It is a sort of assurance to the court also. No other remedy was available, and that's why the petitioner approached this court. So it is entirely the responsibility of the advocate who is suggesting. Every column, every averment, every paragraph of the affidavit should be cautiously filled up. Mostly people show negligence and carelessness towards that, and it is given in the hand of the clerks or those persons who are not well versed with the pleadings. In fact, they do not know in which column particular paragraph should be filled up in affidavit. No, this mistake should not be ever done. An advocate is required to give sufficient time to the petition once it is ready and placed before him, and he should thoroughly check the entire petition from the index, including the sections, articles in which the petition is being filed, his own name, the sequencing of the documents in the index column, then the dates and events, then the petition itself, then prayer clause. While revising the petition, some new idea can come to his mind and prayer can be modified, so still a chance is left for improving the petition and the prayer itself. Then the enclosures, whether the enclosures have been placed in a proper sequence, whether the documents which are required to be filed, only those documents have been filed, no unnecessary superfluous document has been annexed therein, or any wrong document at a wrong place has not been done. Then comes the affidavit part. The advocate has to see whether the affidavit columns are properly filled up. Necessary details of the deponent has been given in there. Then comes the wakalatnama. Wakalatnama is an authorization by the petitioner, by the petitioners, by the clients, authorizing the advocate to plead on their behalf, to take certain decisions to a limited extent. So wakalatnama also requires signature of the witness and his details, as well as signature of the advocate, signature of the clients, all the clients. Wakalatnama has been given in Civil Procedure Code also. CPC describes the content of the wakalatnama. So in this way, the petition gets completed here. Once an advocate is satisfied that the petition is complete in all aspect, then only he should give clearance to his clerk for filing or reporting, etc. Thank you. Advocate has to exercise a lot of caution in preparing the case, in drafting the case, in dictating the case, in finalizing the petition as well, and the relief and prayer, and then preparing his argument.